Let's continue to talk about this major story, and friend of the program, former federal prosecutor and legal analyst Doug Burns joins me now. Doug, thanks so much for being with us. We've been talking about this all day. Wanted to get you on, though, for your thoughts. First up, though, do you agree with Kevin McCarthy and other Republicans? This is a slap on the wrist for the president's son.
It's a tricky question, actually, that you're asking me. I mean, I've been in many, many tax cases as an assistant U.S. attorney. There are a lot of different things to be discussed, which is that in the Department of Justice, you have the tax division, one of what we call the litigating divisions, and they pretty much give the line assistants marching orders on what plea they can or cannot accept, which is interesting. So the point is, if you want to take a plea to something other than, what we call the top count, the highest provable tax count, you need to get tax division approval, main justice approval. I know I'm getting a little in the weeds, but the reality is I'm going to argue this both ways. On the one hand, as a veteran of tax prosecutions, on $1.5 million income for 2 years, very often you would see a felony level charge. Let me clear up a couple of the red herrings that went out today, that caused what I'll call some head fakes. They talk about he owed $100,000. No. He didn't owe $100,000. He owed way, way, way more than that. The charging document says that on $1.5 million, he owed more than $100,000. That was a very cute head fake by DOJ to make it seem as though he owed $100,000. He owed far, far, far more than that. So again, right out of the gate, I've seen many, many tax cases where if you have $3 million in income and taxes not paid on it, it's going to be a felony level charge. However, and this is important, in this particular case, Hunter Biden apparently took steps to step forward, Andrew, and pay back the money. Some nefarious storylines about how a wealthy lawyer from the West Coast put up the money, but that's irrelevant. The reality is that Hunter Biden, the defendant, apparently cleared this up, and that's a factor. Real quick on the law, for the armchair Googlers, 26 United States Code 7203 is failing to file a return. That's a misdemeanor. But there's a second prong to that statute, which is failing to pay the taxes. Yeah. You just simply didn't pay the tax. That can be a misdemeanor. Okay. Tax evasion, 7201. Tax evasion is taking steps to hide it, having two sets of books, things like that. So again, I'm not going to argue it either way. I mean, it is a little bit lenient, certainly. But that's what they decided to give him. I do have thoughts on the firearm thing, though.
Yeah, let's get into that. And now that was a felony, and he didn't report that he owned one when he bought one, that he was either ongoing or previous or current drug addict. So let's go into that specific statute there. What did he violate there?
Well, that's again, I'm ticking off the sections. 922G3, George G3 of Title 18. Taxes are in Title 26. 18 U.S.C. 922G3 makes it a felony to possess a firearm when you are a user of drugs, a drug addict, etc. Now, today that was the second big head fake, but I will give uncharacteristic kudos, seriously, to even the so-called mainstream media, because they've been reporting correctly all day long, to their credit. I'm serious, that he's getting a dismissal on that, a deferred prosecution. Nevertheless, I'm sure a lot of people are walking around today because everybody's busy. We're all working, going to our jobs, saying, oh, and there's the felony gun charge also that he's taking. No, he's not. It's a deferred prosecution. And what that means, Andrew, is that he will go through a 2-year period of essentially pre-charging probation. And if he successfully completes it, the case is dropped. There's no prosecution whatsoever for the felony gun charge. Okay. And so that will leave him convicted of 2 misdemeanors only. And a lot of people on the right, real quick, are expressing some consternation about giving him what we call a DP, a deferred prosecution on the gun charge. Yeah.
Doug, though, let's get into the fact because, this has been ongoing for 4 or 5 years, back during, I believe, the Trump administration. This is a Trump-appointed attorney, David Weiss, there in the U.S. District Court of Delaware there in Wilmington, looking into this. So there's been several years, and then we find out today both the charges themselves, the indictment, but also simultaneously announcing that that plea agreement has been brought. So it took a really long time to bring these specific charges. What do you make of that? Because we've been talking to people all day, and the charges may not have necessitated such a long investigation.
Well, yeah, that's true. I mean, but again, now you're morphing me into the political side of this. You know, this is a legal discussion and a political one. This is the son of the President of the United States. That should be completely irrelevant. That should have nothing to do with anything. It shouldn't matter whether the defendant is Mother Teresa or Charles Manson, as I like to say. You look at the facts and you adjudicate the case accordingly. But that's not the way it works, because we're human beings and we are governed by human nature. So I'm not telling any tales out of school when I tell you that when I was in the United States Attorney's Office, if it was, oh, Doug, did you hear so-and-so's got a tax case and the defendant's father is the senator from, that's human nature. So this went on way, way too long. It never should have gone on for 5 years.
And it's ongoing, according to David Weiss.
Say it again?
And it's ongoing, according to Attorney David Weiss.
Well, thank you. Yeah. I'm very glad you made that point.
But I don't know what that means, though.
No. Once again, under politics and law don't mix.
Yeah.
Okay, you turn around and you've got the defense lawyer smiling, essentially, and saying, the case is completely over. That's it. Okay? And then in the next breath, you have the United States attorneys telling you the case is ongoing. The case is not ongoing. That's ridiculous. That's patently absurd, in my view. And the bottom line is that, it never should have gone on for 5 years, as you just said, Andrew. And, you give the guy 2 misdemeanors. And then the other thing is that rarely, if ever, seriously, does the United States Attorney's Office agree to recommend probation. In my home district, which isn't dispositive of the country, the EDNY, Eastern District of New York, we would almost universally take no position on sentence. That's what we were taught. That's what we did. That's what was implemented in the plea agreements. But here, it does have some overtones of a little bit of a sweetheart deal. But I want to be fair. I'm not going to get all over the skis and start ranting and raving about how there's a ridiculous double standard in this country. That's not fair. But it's also not fair to stand there and say this is really the most accurate resolution here, because that's not true either. Yeah. Once again, the truth is in the middle.
Sure.
It always is.
Sure.
So there are earmarks of special treatment, and then at the same time, he did pay the money back, which is relevant in a tax case. And the gun charge, though, to get a DP, a deferred prosecution on a gun count, it is a little bit unusual. But then again, this isn't a gun count like brandishing or using a gun. Sure. This is lying and being untruthful on the form, and there's a difference there as well.
Okay. Doug, though, while I have you, and we just have to remind our viewers, I think our viewers know, this is not the end of Hunter Biden's legal troubles. Obviously, that case in Arkansas regarding his child with his mistress. It's not a paternity suit per se, but it's over alimony payments and whether or not, President Biden's grandchild via Hunter and this woman will be able to take the Biden name. And so that's ongoing. These congressional investigations are ongoing into alleged financial improprieties with members of the Biden family, including Hunter Biden. So it's not over for them. But I want to just kind of segue here very briefly because Bret Baier interviewing former President Donald Trump today and yesterday in a 2-part interview, and I think it's fascinating. A lot of information was gleaned from the former president because of Bret's great questioning. And everyone has been talking about the questioning when it comes to the classified documents case. We know a tentative date for a trial has been set for that in late August. But a lot of people are asking themselves at the news that Hunter Biden made a plea deal, and they're asking themselves, I saw this a lot on social media today, why didn't former President Trump and his team of attorneys make a plea deal with Jack Smith's team, the special counsel? Is it fair to compare and contrast these two cases or not fair? That's something I was thinking about today.
Well, it's a great question, but I'm not so sure that it necessarily is fair. I mean, the Trump case, real quick, once again, can be looked at through two completely different lenses. The one lens is how he engaged in all this horrible and terrible behavior, but then the other lens is that the guy was just incredibly careless and sloppy, had all these boxes of stuff, which really isn't a federal case. However, as I've told you many times right on this show, he should have given the stuff back, and he brought the problems on himself. You had asked me a question, privately, which is interesting, and that is the interview admissible in court? So let me just answer that real quick. An out-of-court statement by somebody is generally what we call hearsay. However, if the defendant is making statements, but it has to be against their own interest, that's interesting, then it's an exception to the hearsay rule. So the lawyers would be debating up and down, arguing. His lawyers would argue the statements weren't against his interest at all. He was making it in his interest. And I've been in a couple of those. I specifically remember one, sadly, where the judge is no longer with us. We were going back and forth as to whether it was against interest. So, you've seen stuff, Andrew, about how lawyers are opining that it's inadvisable to do those kind of interviews. I generally agree with that, by the way. But back to the comparison of the two cases, this is where, again, you have to be, dancing on eggshells. I mean, some people say, oh, you're talking drugs and guns. It's so much more serious. I don't do any of that over the ski tip stuff. But the cases are different, okay? Hunter Biden, unfortunately, went through a period in his life where things were really, really out of control, okay? He didn't pay taxes on $3 million. He did lie on a gun form, which is a federal felony offense when you get right down to it. Donald Trump, on the other hand, honestly did not engage in anything all that serious. However, I think it's viable, as all the experts, Bill Barr, all of them, viable to say that, he dug his own grave in the case. As far as pleading guilty, forget about that. Donald Trump, it's not within his DNA, not within his constitution. I could go on 20 side seminars. He was schooled by Roy Cohen. People can read the book Citizen Cohen by Sidney Zion, great book. And Cohen's whole philosophy, scorched earth, never admit anything. I'm not so sure those are the correct skill sets to bring to politics, by the way. It's another discussion. But the point is, Donald Trump ain't never pleading guilty to anything, okay?
Okay. Doug Burns, we'll leave it at that. As always, thanks for a lively discussion, and we'll talk again.
Appreciate it.